a couple of nights, and we know a lot of people that lost their homes. Thankfully, ours is not one of them. And so I guess having our kids out of school for an entire month isn't so bad in the grand scheme of things. So anyhow, let's talk about FMLA, because it is one of the most confusing laws that can lead to the most number of lawsuits just for making little tiny technical mistakes and errors. I mean, it's Wednesday. I got a call on Monday from a HR rep at a very large company who is picking up the pieces after a former HR rep left the company. And one of those pieces that she had to pick up was the fact that an employee who's currently out on a leave of absence, an extended leave of absence, was given one of the great congratulations, I hope this letter finds you well. You've exhausted your FMLA leave, so good news, you're fired. And thankfully, I think we caught it in time that we can manage that and fix it and send a new letter that says, please disregard the letter you just received. But the FMLA is a tricky law, and we want to make sure that everybody understands the ramifications of what it means to just not only provide the leave, provide the notice of the leave, and what to do at the end of the leave to make sure that you're still protected. So some of the things that you want to consider when somebody is disabled or injured is, of course, not just FMLA, but are workers' compensation laws triggered? And I always ask that question when a client calls me and says that somebody's been injured or somebody's alleging stress leave. You know, first I say, well, is it work-related? And if they claim that it's work-related, be sure to give them that DWC-1 form. Another thing to consider, especially if you do business in California, is there a separate pregnancy disability leave statute to take into consideration? Because out here we have pregnancy disability leave separate and distinct from FMLA. And we also have the California Family Rights Act, which is basically the California version of FMLA, which offers significant more protections to disabled employees than FMLA does. And then we'll talk a little bit about the duty that every employer has to not only offer a reasonable accommodation, but what does that mean? And hopefully I'll be able to cut through some of that for you today. And then, of course, what are your obligations to continue health benefits, and what other designations of leave and seniority and vacation time and those sort of issues. So let's start with the basics. FMLA. Under the FMLA, covered employees must provide, right, hopefully we all know this, up to 12 weeks of unpaid job-protected leave to all eligible employees for the following: incapacity due to pregnancy, prenatal medical care, or childbirth, care of the employee's child after the birth or placement for adoption or foster care, care for the employee's spouse, son, daughter, or parent with a serious health condition, or the serious health condition of the employee that makes the employee unable to perform their job. You know, a couple of weeks ago, I got another very interesting FMLA issue where this is an employer who employs about 150 employees, and he had a bookkeeper who was pregnant with a surrogate child, and so she gave birth to the surrogate via C-section, and unfortunately this employer sent a text message to her after 2 weeks saying, when are you coming back to work? Because he was under the impression that because it was a surrogate pregnancy, that once she gave birth, 2 weeks was plenty of time to recover from that, and then she needed to hurry up and get back to work. So I want to be clear that yes, indeed, pregnancy and actually giving birth, it's not about baby bonding time. Those are other laws that cover baby bonding time. But if a pregnant employee gives birth, they definitely get a couple more weeks than just 2 before they come back to work. It doesn't matter if it's their own child. Okay, eligibility. Employees are eligible to take leave if they've worked for a covered employer for at least 12 months, if they have 1,250 hours of service in the previous 12 months, and the employer has at least 75 employees working within one of its main sites, and 50 employees within 75 miles of one of their main locations. And what is the definition of a serious health condition? We're going to be doing a lot of this morning. What does it mean when you say reasonable accommodation? And what does it mean when you say serious health condition? So it's an illness, injury, impairment, physical or mental condition that involves either an overnight stay in a medical care facility or continuing treatment by a healthcare provider. And it must actually prevent the employee from performing his or her job, or that prevents one of their qualified family members from participating in daily life activities. Continuing treatment, what does that mean? Well, it's a period of incapacity. These are all legally defined terms because there's been, of course, hundreds of cases that litigate the meaning of all of this. A period of incapacity of more than 3 consecutive calendar days combined with at least 2 visits to healthcare provider or 1 visit and a regimen of continuing treatment. There it is again, incapacity due to pregnancy. That includes morning sickness, bed rest, you know, any of those related conditions. And then, of course, incapacity due to a chronic condition. That can be cancer, that can be rheumatoid arthritis, that can be GERD. You know, there's all types of different conditions that qualify under that. Now, the basic military FMLA leave entitlement covers all eligible employees with a spouse, son, daughter, or parent on covered active duty or called to covered active duty. And they get the same amount of leave in order for qualifying reasons such as attending military events, arranging alternative child care. That is an issue that is now near and dear to my heart and several other people that I know in Ventura. Addressing financial and legal arrangements, attending certain counseling, counseling sessions, and attending post-deployment reintegration briefings. Eligible employees may take up to 26 weeks, so not just the 12 weeks, but 26 weeks of leave during a single 12-month period to care for a covered service member. Then current members of the armed forces undergoing medical treatment, they're covered. Another covered service member would be a veteran discharged or released during a 5-year period prior to undergoing medical treatment for that current condition. Use of leave. So the easy ones, right, are when somebody has to go get surgery, when somebody's giving birth to a child, when somebody has to go take care of an ailing parent. The easiest thing is they want their 12 weeks. That's the easiest role for an HR representative to deal with in the company. Okay, you're leaving January 1, here's your notice, you know, you'll be back, your leave will expire at the end of March, you'll be back April 1, give or take. That's easy, but employees can also take leave on an intermittent basis or when, quote, medically necessary. And then, unfortunately, you have the burden as the employer to make certain accommodations and arrangements that we'll discuss in a bit. Employees are supposed to make reasonable efforts to schedule their leave for planned medical treatment so as to not disrupt the employer's operations, but we all know that that hardly ever happens. And even if they don't do it, if they fail to do it, again, the burden is back on you as the employer to say, oh, that's okay, you know, we're here to help. We're still going to give you that notice and give you the leave that you're entitled to. All too often, employers make the mistake that they can terminate an employee who has exhausted their 12-week leave entitlement, and that is what I briefly discussed a moment ago, but that is the #1 way to just walk yourself into a disability discrimination lawsuit, is to terminate somebody because they have exhausted their 12 weeks of leave. Yes, the law, if you actually read the FMLA law, it says, well, you're given 12 weeks of job-protected leave. So that means you can't be fired during that 12 weeks. Where employers make the mistake is that they think that the next sentence in that paragraph says that once you've taken 12 weeks in one day, you can be fired. And it absolutely doesn't say that. What it says is that you can't be fired during that 12-week period. But you, in fact, can also not fire somebody beyond that 12-week period because they are disabled. They're considered disabled. And again, we'll talk about that a little bit more. Another question that comes up a lot is well, when they're on their leave, how can they get compensated? Sometimes there's state disability benefits that they can collect. Sometimes there's state programs like we have in California called paid family leave benefits that offers paid leave for up to 6 weeks. Sometimes there's sick leave, right? Like especially in California, again, we mandate 3 days of paid sick leave. So can an employer require their employees to use that sick pay when they're on leave? And then, of course, there's their PTO. So the answers are, it depends. But in general, for FMLA purposes, employees may choose or employers may require them to use the use of accrued paid leave. And that's fine under FMLA. In California, it's not. Employees must comply with the employer's normal paid leave policies. So if, for example, the employer has supplemental disability plans, and a lot of employers do, that say, hey, look, if you're disabled, we're going to supplement your missing salary or whatever for up to 6 weeks with a temporary disability plan that we pay for. But before you are going to get that benefit, we are going to require that you use all of your saved PTO. That's perfectly fine. You can do that. When it comes to health coverage, the employer must maintain the benefits in the same manner that they maintain those benefits when the employee was actively employed. And the employee must be restored to their original or equivalent position with equivalent pay, benefits, and other employment terms at the conclusion of their leave. Okay, intermittent leave. This is the one that causes a lot of headache. Taking leave in multiple blocks of time because of a single qualifying reason. And then there's reduced leave, which is a change in an employee's work schedule, meaning shorter hours per day or a shorter number of days per week. Both of those are okay. It is unfortunately, once again, your responsibility as the employer to keep track of all of the hours and catalog the hours towards their 12-week FMLA allotment. But again, even when they've exhausted the leave, if they're still disabled or if they still have a qualifying medical condition that requires extended care, you are still required to make accommodations for them even if they've exhausted that leave. So reasons why an employee can take intermittent leave: again, medical necessity related to a chronic serious health condition of them or a covered family member, and usually this is going in for cancer treatment. Also, medical necessity related to a planned expected medical treatment of themselves or a covered family member. It can also be medical necessity related to covered service members, serious injury or illness, a qualifying emergency relating to covered military service, and then, of course, the birth, adoption, or foster care of a child. Intermittent or reduced leave is not available for voluntary treatments or procedures. It's also not available if, here we go again, if, quote, the essential job functions cannot be performed during working time. So it can't say, an employee can't come to you who works as a receptionist in your front desk from the hours of 8 to 4. She can't say that, well, I want to work from 6 to 8 in the morning, and then I want to take 8 until 4 off, and then I want to come back and I want to work from 5 to 7. You don't have to do that because obviously she's a receptionist and you're not open between 6 and 8, and you're not open between 5 and 7. That's the easiest example I can give you. Employees who do not make reasonable effort to schedule planned medical treatment that does not disrupt the employer's business operation technically are not entitled to take the leave, but as I already mentioned, you as the employer have the burden, especially here in California, to prove that their inability, the employee's inability to make that reasonable effort is going to place an undue burden on you and your business. So you still need, at the end of the day, point is, you need to give it to them, and the burden is on you to prove that what they're asking for is too much. Employers may transfer employees taking intermittent or reduced leave to a different position as long as it's equivalent pay and benefits. And of course, it must comply with any collective bargaining requirements or agreements that are in place. But if somebody, again, let's go back to that receptionist. The receptionist wants to work from 6 to 8. If you have some other position that she could do in the company, like I don't know if she's qualified to be a janitor and she wants to come in and sweep the floors from 6 to 8, if that was something available that you would agree with, then that's something that you can do and still stay in compliance with the law. You can also modify an existing job duty to more appropriately accommodate the employee's intermittent or reduced schedule breaks. But one thing that you cannot do is require employees to perform duties while taking their leave. This, again, let me go back to that example I just brought up of the woman who was a bookkeeper who also did payroll, responsible for payroll for this company. And she just had her baby, and 2 weeks later, she was called back into work. Well, she actually wanted to work from home. So she's on FMLA leave. She's getting all of her vacation pay. She's receiving disability benefits, and she actually wanted to also work from home and get paid by the hour for that time. That's a really big no-no. So not only if the employee wants it, you shouldn't do it, and you absolutely should not require the employee to do any work while they're on leave. Counting intermittent leave, this is difficult, but incremental or reduced leave can be counted using increments no greater than 1 hour. And if smaller increments are offered pursuant to the employer policy, they must use the smaller increments to count the leave. So I always recommend that your policies are very clear that you can't take leave in any increment lower than an hour. Employers are not permitted to count any hours not actually taken as leave, except when it is not physically possible for the employee to begin working in the middle of a working day. So sort of technically what I just explained with you with the receptionist, but the example here is a flight attendant on an airplane. If an employee cannot work the normally required overtime that they would normally work, like you've got employees, and this happens a lot in manufacturing industries, if an employee normally works 8 hours regular, but they're just scheduled for an 11-hour day, and the employer knows that they're working 8 hours of regular time and 3 hours of overtime, then because of the intermittent or reduced leave, like I said, dip below the 11 hours, then the required overtime hours could in fact be counted against the employee's FMLA leave. So if their regular schedule requires 11 hours a day, and because of the leave that they need, they can actually only work 8 hours, you can in fact count those 3 hours of overtime towards the leave requirement. But again, at the end of the day, the message I'm going to say 100 times is that it doesn't matter when they exhaust it. You still have to give them the accommodation, or at least have a serious conversation about whether you can continue the accommodation. But for terms of counting those hours, this is acceptable. But again, if the overtime hours are not required but they're voluntary, then you can't do it. It's only if the schedule is always you're working a 10-hour shift, you're working an 11-hour or 12-hour shift. Okay, so this is, again, the hardest part when it comes to FMLA leave, I think, is the intermittent leave challenges. So lots of employers have trouble determining eligibility for leave for employees whose hours vary from week to week. So like waitresses, for example, or catering companies or party event companies where your hours are not set. What you have to do is you have to take what they've worked as an average of the past 12 months or 6 months or quarter, depending on how long they've been an employee, and then determine what their average hours are for a week. All right, compensation. So obviously we all know there's exempt and non-exempt employees. For exempt employees, those are the ones that are earning a straight salary and don't receive any overtime pay, employers may dock their pay for the hours those employees are on FMLA leave without affecting their exempt status. This is the question we get all the time in California. I have an exempt employee. He or she has exhausted her vacation pay bank, she's exhausted her sick bank, and she's taking a day off, so can I dock a day of pay? The answer to that question is yes, you can, but cautiously, because there's two requirements in order to be considered an exempt employee. Under federal law, there's only one. You have to fit within one of the three duties tests. You can either be executive, administrative, or professionally exempt from overtime. And in fact, the federal government under the FLSA also has something called the white-collar exemption, which says it doesn't matter if you're flipping burgers. If you're making $115,000 a year, then you're automatically exempt from overtime. It doesn't matter what you do. California is different. In California, you have to have there's two bases to be exempt. First is you have to satisfy that duties test. You have to be professionally, executively, or administratively exempt, and you have to meet the salary test, which is 2 times the minimum wage for every week that you work. So currently, our minimum wage is going to flip to $11 an hour starting on January 1. So $22 an hour is the minimum amount of money they can make. So 22 times 40 hours, that's their minimum weekly rate. If you dock their pay one day and they dip below that weekly minimum, technically, and I'm sure that, they're not going to probably run out and sue you for that, but technically if they dip down below that weekly minimum, then they're no longer exempt. So I always say err on the side of caution, and if you're paying your employees exempt, then that means it's a double-edged sword. Once in a while, they're working 60, 70, 80 hours a week for you, and you don't have to pay them overtime. The flip side of that is that if they've exhausted their PTO bank and they need a couple of days off, you should just continue to pay them that weekly salary. To me, that's the safest way to go. Otherwise, just keep everybody on an hourly rate. However, both the employer and the employee, if there's these agreements about their weekly rates, must be in the agreement that the salary compensates them for all hours worked, and the employee also receives appropriate overtime compensation of 50% more pay for all hours worked over 40 in a week. It's just not worth it, in my opinion. Okay, during FMLA, the employer must maintain employees' health coverage. We already talked about that. On return from leave, most employees must be restored to their original or equivalent positions with equivalent pay, benefits, and other employment terms. So, this just means they should come back to their exact same position, their exact same supervisor if possible, their exact same team if possible, maybe their exact same office and desk if possible. You don't want to make it look like you as the employer have taken any sort of adverse action against them for taking that leave of absence. And when they return, it's basically like, welcome back. And what I hear a lot is, we hired somebody as a temp when our employee went out on FMLA leave, and we really liked the temp better. We really want to keep this person, and we want to fire the person or not bring back the person who's been out on FMLA leave. And unfortunately, really, you need to fire the temp. When you hire somebody to replace an employee who's going out on FMLA leave, you need to be honest with that new employee and say, we are hiring you because somebody's going out on maternity leave or somebody's taking a leave of absence. And this may, in fact, just be a temporary position. This is the same slide. I apologize for that. Okay, this is the next thing. This is the next area where employers make the biggest mistake, and that is informing the employee that they're eligible. And again, I'm going back to the example of the bookkeeper who had the child 2 weeks and was called to come back to work. when I was having a conversation with the employer, I asked all about the FMLA leave, and the response I got was, again, I didn't think that she was entitled to FMLA leave because it wasn't her baby and it was a surrogate baby. So I said, okay, so did you provide the notice? She said, like, obviously not. So I said, well, today, as soon as we get off this phone call, we need to draft the letter and provide the notice, because it doesn't matter if your employee's been out for 16 weeks, which obviously more than exhausts the 12-week entitlement. If you don't provide the notice, it doesn't exist. Notice has to start from when you in writing say your FMLA starts today. It doesn't go retroactive. All right. Absolutely never, again, just like this particular employer, never discourage an employee from taking or using their FMLA leave benefit. Don't ever suggest that, for example, they delay the surgery. Don't mischaracterize the leave. So, you know, again, don't just assume that because it's surrogate pregnancy, it doesn't qualify as a serious medical condition that would result in FMLA leave accommodations. Are you entitled to receive a copy of the medical diagnosis that is causing the employee to take the leave? No, you are not. You are, of course, allowed to get a doctor's certification, but that's all that you're entitled to do. There's a nice form that's attached to the FMLA notice forms that says doctor's certification, and it's required that that be submitted within 5 days that the notice is given. But, you know, you're not entitled to know what the reason is. And I have had a lot of questions come up about that over the years. You also are not a doctor. So if you get a doctor's note from some doctor that doesn't make any sense to you, or it sounds like it's not a real doctor, or it sounds like it's a, you know, somebody who got their medical degree online or something like that, it doesn't matter. As long as they filled out the doctor's certification, you don't have a right to get a second opinion. You do have a right to get a second opinion at the conclusion of their leave, however. If they want to continue their leave and they recertify, you can ask for a second opinion. Oh, I want to go back to cautionary tales. So, as we talked about in the beginning when I was mentioning the workers' compensation issues and the state leave issues, what we need to really focus on is what happens at the end of an individual's FMLA leave. So when they've exhausted that 12-week entitlement and you contact them, what do you do and how do you do it? I have the letter for you. What it essentially says is, Dear John Smith, as you know, you started your FMLA leave on January 1, 2017. Your FMLA leave has expired as of March 31st, 2017. You're due back to work April 1. We understand that you need to extend your leave because you've received a doctor's note extending your leave for another 8 weeks. At the conclusion of that 8-week period, please contact us and we will place you in the first available position for which you are qualified. And then as a reasonable accommodation, we are providing you with an extended medical leave of absence. That's essentially all you have to do. If you have all those keywords in that document, you're safe. You are safe from a lawsuit. It's just as simple as that. Because what you're telling the employee is, number one, we are not discriminating against you because we put you on FMLA. Number two, we're notifying you, so we're complying with our responsibilities to notify you of when you have expired that leave. And number three, we are using the golden word as a reasonable accommodation. We are placing you on an extended leave of absence. That satisfies the ADA requirements, the FEHA requirements here in California, and the CIFRA requirements that says that you can't discriminate against somebody who's disabled. And then finally, you're not firing them. What you're doing is you're placing the burden on them to provide you with an update. When the doctor has released you to return to work, contact us and we will place you in the first available position for which you are qualified. Now guess what? Here in California especially, this happens all the time. In California, when you are disabled, you can collect up to 1 year's worth of your pay, a whole year. What is the pay? It's 70%, well, no, 60%, 60 to 70% of your salary. You get to collect that tax-free. So essentially, if somebody's disabled for an entire year, as long as they keep submitting doctor's notes, they're sitting at home collecting a paycheck that's pretty darn close to the paycheck that they were receiving from you, because the paycheck they received from you has taxes taken out. And here they are getting that same amount. It's already post-tax. So anyhow, this happens all the time. They'll just keep submitting doctor's notes. And you know what? This leave needs to be extended. This leave needs to be extended. This leave needs to be extended. And then at the end of a year, without fail, they will have a doctor's note that says, this patient is fully released to return to work. Okay, so if they left January 1, 2017, the note will say, this patient is fully released to return to work January 1, 2018. So now what do? Well, it's been a year. And you keep sending those letters that say, we're sorry that, well, no. You keep sending those letters that say, we are in receipt of your doctor's note. We understand that you're going to be on another leave of absence for 6 weeks. We are going to extend your leave of absence as a reasonable accommodation. Please contact us at the conclusion of your leave. So you've kept up with all your responsibilities. That's great. Now she's ready to come back to work. You really don't want her to, and I know that, and that's why I've been on the phone with you every 6 weeks during this whole process. So when she comes back, what's the next step? You have to do what's called engaging in the interactive process. Now, engaging in the interactive process means you sit down with them. I encourage that to be a face-to-face meeting. If it can't be a face-to-face meeting, you can do it over the phone. And you say, okay, we got your doctor's note. I understand that you're ready to come back to work on January 1, 2018. Here are all the available positions that we have. Now, you are only required to hold their exact position open for that 12-week period. So like I said, you have to pretty much fire the temp, right? But if she's been gone for a year, you're absolutely able to fill the position so long as you have other positions available that if she were to call back the next day, you could place her in that position. But point is, end of the day, at the end of that year, as long as you engage in that interactive process and you say, here are all the positions that we have available that you're qualified for, are you willing to take this position? As long as you make that offer, even if it's a lower position with a little bit less pay because she's been out for so long, that's perfectly acceptable and will save you from the lawsuit. And most likely she's not going to take it, and then you get to walk away from having this employee on your hands. Failing to do it correctly, however, can cost a lot of money. And I'll leave you with, right before we go into questions, I'll leave you with the best example. And hopefully, I wish you were all here in front of me so I could quiz you, but I think you can all get it what I'm about to say. An employee went out on a leave of absence on May 1, 2016. The doctor's note said he would be out for 12 weeks. My client very appropriately placed him on FMLA leave. At the end of that 12-week period, they got a doctor's note that put him out for another 6 weeks. My client sent a letter saying, we accept your doctor's note and we'll see you in 6 weeks. Well, then they got another note, 6 weeks. And then 6 weeks later, they got another note putting him out for another 6 weeks, and another 6 weeks, and another 6 weeks. Now, in February of 2017, my client sent a letter that said, we've now received your 6th letter extending your leave of absence for another 6 weeks, and we can no longer accommodate you, so we're fired. You're fired. So very obviously, he went out and got a lawyer, and I got a lawsuit on my desk. And when I discussed this with the client, I said, so you've been accepting his leaves, his doctor's notes every 6 weeks for about 7 months. What triggered you to send this letter saying we can't do it any longer, you're fired? Well, they were under the impression that they had to actually hold his position open for that whole time. And I said, no, you can fill it. You can fill it with a temp. You can fill it with another person. But it's the act of terminating him that's caused this problem. And then, of course, the next argument I get from the client is, well, he's been out for 9 months, right? So because he left in May of 2016, and this is now February of 2017. 9 months. Are we supposed to hold his job open for 9 months? No. Are we supposed to give him a reasonable accommodation for 9 months? Yes. Okay, so here's the law. If an employee tells you that they're going to be out and they don't give you a return date, you don't have to hold their position open, because there's no duty under the law to provide an indefinite leave of absence. Okay, that is 100% true. If you've been listening to me, this individual was out in May, and in February he was terminated because, according to my client, he was never coming back, because every 6 weeks my client would get a new note. But the key is that it was every 6 weeks. So it wasn't an indefinite leave of absence. It said it was just another 6 weeks. And because you as the employer are not a doctor, you can't say that even though the cumulative effect of every 6 weeks was technically an indefinite leave of absence, it's not, because there is an end date. So there's just no reason to send that termination letter. That's really the bottom line, because then, unfortunately, we're stuck in a position where we still end up having to resolve these claims, because you got to